coming back to the conversation in regards to the Supreme Court and the NASA petition, of course, you were able to follow through with the 5-hour submission made by, the lawyers representing NASA. I know that, I don't know what you call that, you're not supposed to do sub judice. We've learned so many legal terms. So, yeah, it's sub judice. But just, maybe a brief overview of really what you think about, the evidence that they've been able to bring forth so far. I'll start with you, Muregi, on that.
Let me say this. I would there were two limbs and what we're saying. And what I get from NASA, what NASA is saying is that elections are supposed to be done in accordance with the Constitution. Yeah. Article 81 and 86 of the Constitution are clear that those are the principles that the IEBC is bound by. That in any event, if it is shown that they do not comply with Article 81 and 86, then the entire process is a nullity ab initio. And so that is the basis on which, regardless of the numbers of whether, if you call those transgressions, even if you say that there are any transgressions, regardless of whether those numbers are going to affect the result or not, then what should happen is that the result should be annulled. Now, the other thing that I got to hear NASA say is that they want the Supreme Court to depart from their decision of 2013 on the issue of the burden of proof in election petitions. And essentially what they were saying, if there is any committal of an offense, an electoral offense, then we go to the normal criminal standard of proof that is beyond reasonable doubt.
Yes.
If indeed this is a civil matter, that election petitions should be treated as civil matters, and therefore we should stick with the normal burden that we know that is what we call beyond reasonable proof. So they were saying that the precedent that was said by Supreme Court in 2013 should be reviewed for that purpose.
Right.
And then the other issue was on Section 83, about what the Supreme Court held in 2013. The Supreme Court held that 2013 is one rule. That one, you have to show that the election has not been done substantially according to the law, and that affected the end result. But
Correct.
What NASA was saying yesterday is these are two rules. One, that it is enough for you that the election was not done in accordance with the law. That is a ground by itself.
Yes.
That there is also the other rule that even if there were transgressions, if it was not done in accordance with the law, you have to look at whether it affects the final outcome.
Results. All right, Duncan, your thoughts on this, especially just looking into the submission by James Orengo and Otiendo Amolo.
My take is that NASA has actually took a position whereby they were saying that elections must they must actually be conducted in accordance with the Constitution, and any dereliction from that should actually lead to a nullification. It actually means that your first point of departure, according to NASA, is the Constitution, and that is where Article 81 and Article 86 comes in, which looks at both the substantive, at both the qualitative and quantitative aspects of an election. And if they say to them, if there's any of the articles which are infringed by the process, then even without going into the nitty-gritties, that is valid enough. That is reason valid enough to actually nullify an election.
Yeah.
When you look at the other aspects that they brought out, they actually went now deeper into trying to bring out issues of irregularities. And why were they bringing these issues out? It is because of the Elections Act. The Elections Act, and my learned colleague has aptly put it, in Section 83 is very clear in terms of what you are supposed to do. And it borrows from the common parlance in terms of the burden of proof in election petitions, which is election petitions generally are sui generis. That means they are in a class of their own. And they always say that you must demonstrate or prove your case on a level that is not on a beyond reasonable doubt, which is normally a criminal level, and there's the civil matter where we call it on a balance of probability. So in between here, which lawyers have not given it a name, that's why we always say in between. I hope we'll find a name. That's where your proof lies.
Okay.
However, neatly coupled with that is Section 83, which says that elections can be nullified when they are conducted in a manner that is not substantial or in accordance to the laid down rules and regulations. But more importantly, there's another limb that says that, or if you demonstrate that these particular irregularities have affected your results.
All right.
So if you hear NASA talking, they're actually saying that they want to depart from the 2013 ruling, as aptly quoted by my learned colleague, and they want to say that, no, the Supreme Court was wrong. It is actually, our law says that you must demonstrate either.
Okay.
It is not at the same time as held by the Supreme Court then. And that is the argument that the Supreme Court must actually make, because once they make a decision on that, then every other thing will actually fall in its place.
All right. And it's interesting that you say that. We just want to listen to something that was said yesterday during the court session in regards to the weight of evidence that the judges really need to make and decide on this particular issue. Let's just listen to it.
You will note that in the submissions made by the Honorable Orengo, he submits that a number of votes that have been cast, and this is also shared by Paul Otiende Amolo, that out of the 15-odd million votes, only 23,000 of them are in doubt. My Lord, the maxim of law used to be de minimis non curat lex. Professor Juang taught me that, and he'll remember. Of small things, the law knows no cure. And I'm submitting to us that what we have here are petty grievances, administrative errors, and no court in the world has ever nullified a presidential election on the basis of what falls under the de minimis rule. The second presentation made to you is through the submission of my good friend Otiende Amolo, who brings to the table what he calls numerical and non-numerical issues. And Otiende, in his submission, says that this court should only focus on what he describes as the substantive. In other words, numbers do not matter in an election. My lords and your ladyship, what then matters in an election? What matters in an election is that individuals come and vote, and those votes are counted, and the voice, the will of the people is expressed in that way. My Lord, I refer you to Article 86 of the Constitution, which says that at every election, the Independent Electoral Commission shall ensure that whatever voting method is used, the system is simple, accurate, verifiable. I'll not address you on those details. My good friend Otiende went into characterizing those. Who must verify? In whose eyes must they be simple? Madame CJ, as he then was in the case of Stanley Munga Githunguri, said, the test is the man in the Pangani bus, the ordinary man. What you are shown here, complete with Pythagoras' theorem, to tell us what the voting went, that is not what the test of the election is. The test is very simple. And we have demonstrated through our affidavits that are on record, which I invite you to look at to their full effect, that the system was simple. And I want to imagine that your lordships and your ladyships walked there yourselves. You are identified. You are given 6 ballots. You marked your preferred candidate. That is how simple it was. It does not require Pythagoras' theorem.
Of the most complex statements that probably you'll ever hear this year have just come out from the Supreme Court in this whole process. That's PLO Lumumba yesterday. Remember, he's representing the IEBC, and of course he was just making his remarks in regards to really the